Thousands of Morrisons staff have won their claim for a payout after their addresses, bank details and salaries were posted online. The case has potential implications for every individual and business in the country. It follows a security breach in 2014 when Andrew Skelton, a senior internal auditor at the retailer's Bradford headquarters, leaked the payroll data of nearly 100,000 employees. The file, which was put online and sent to newspapers, included their names, addresses, bank account details and salaries. The personal data of thousands of Morrisons employees was uploaded to the internet and sent to newspapers. Stock photo. A group of 5,518 former and current Morrisons employees said the leak exposed them to the risk of identity theft and potential financial loss, and that Morrisons was responsible for breaches of privacy, confidence and data protection laws. They are seeking compensation for the upset and distress caused. Morrisons said it could not be held directly or vicariously liable for Skelton's criminal misuse of the data, and that any other conclusion would be grossly unjust. Following Mr. Justice Langstaff's decision on liability on Friday, Nick McLeay of JMW Solicitors said, "The High Court has ruled that Morrisons was legally responsible for the data leak. We welcome the judgment and believe that it is a landmark decision, being the first data leak class action in the UK. The judge ruled that vicarious liability, but not primary liability, had been established." He said, "I hold that the Data Protection Act, DPA, does not impose primary liability upon Morrisons, that Morrisons have not been proved to be at fault by breaking any of the data protection principles, save in one respect which was not causative of any loss, and that neither primary liability for misuse of private information nor breach of confidentiality can be established. I reject, however, the arguments that the DPA upon a proper interpretation is such that no vicarious liability can be established, and that its terms are such as to exclude vicarious liability even in respect of actions for misuse of private information or breach of confidentiality." He added, "The point which most troubled me in reaching these conclusions was the submission that the wrongful acts of Skelton were deliberately aimed at the party whom the claimants seek to hold responsible, such that to reach the conclusion I have may seem to render the court an accessory in furthering his criminal aims." Morrisons said it could not be held directly or vicariously liable for Skelton's criminal misuse of the data, and that any other conclusion would be grossly unjust. Stock photo. I grant leave to Morrisons to appeal my conclusion as to vicarious liability, should they wish to do so, so that a higher court may consider it, but would not, without further persuasion, grant permission to cross-appeal my conclusions as to primary liability. Mr. McLeay said, "Every day, we entrust information about ourselves to businesses and organizations. We expect them to take responsibility when our information is not kept safe and secure.